Good afternoon. My name is Carol Mason, and I am the president of John Jay College of Criminal Justice, and I am so pleased to welcome you today to this webinar entitled Before and After Data on the Impact of Bail Reform, which we are proud to co-host in partnership with the New York State Division of Criminal Justice Services. Here at John Jay College of Criminal Justice, we educate and empower public safety leaders of the future. In support of our mission, we convene public officials, scholars, and advocates of today to inform our students and the broader public about the most pressing justice issues in our communities. Today's event builds on John Jay's broader efforts to support safe and racially just communities through our Future of Public Safety initiative. This initiative was launched with a series of public conversations with national leaders on safety, justice, research, and community building that John Jay hosted in partnership with the National Organization for Black Law Enforcement Executives, NOBLE. The resulting Future of Public Safety report provides a roadmap for centering communities in crafting public safety solutions and addressing the racial inequities in our existing systems of safety and justice. We are honored today to partner with the New York State Division of Criminal Justice Services under the leadership of Commissioner Rosanna Rosado to help illuminate the ongoing conversation about the role of the criminal legal system in creating public safety, particularly with respect to pretrial detention and bail. We applaud DCJS for their commitment to leading with facts and data. We also thank the New York State Office of Court Administration's Technology Division for their dedication to data sharing and transparency. I must also acknowledge John Jay's own Data Collaborative for Justice for leading in the development of today's program, as well as producing data and research on the topic of bail reform in New York State. I also want to give a special thanks to our John Jay's External Affairs, Mindy Boxstein and Jennifer Lorenzo, for making this event happen today. We're having this conversation today because over several decades, criminal justice advocates, community organizers, researchers, lawmakers, and other public officials called attention to the inequities of our criminal legal system that disproportionately subjected people of color to pretrial detention because they were unable to pay bail while their cases were being adjudicated. Reforms to New York State's bail regime, which will be discussed in more detail later in this program, were a long overdue response to the inequities produced by New York's pretrial system. These reforms were designed to address these inequities and reduce pretrial incarceration in ways that would support public safety and justice for communities across the state. It's clear that at least some of these goals have been achieved. For example, the Data Collaborative for Justice at John Jay found that in 2020, in 2020. Bail reform led to about 19,000 fewer people across the state to be detained while presumed innocent. Remember that, presumed innocent. Further, while there was an uptick in crime, particularly violent crime in some places across the state during the pandemic, there is no evidence, again, no evidence to date suggesting that bail reform has contributed to this increase. Of course, with any public policy shift, there are challenges in practical implementation, making continued partnership, dialogue, and the use of accurate data vital in order to meet those challenges. This presentation also builds on the day-long New York State Bail Reform Conference that John Jay and the Data Collaborative for Justice hosted in May of this year, where a diverse group of stakeholders discussed the promise and challenges of bail reform, as well as the limitations of the existing data on this important topic. A little later in the program, you will see some highlights from this convening. Today's webinar will cover what we do know about the impact of bail reform, including by offering new data to inform the ongoing statewide dialogue. Again, we want data to inform this conversation. So that's why we're so grateful for DCJS for championing transparency and encouraging an informed public discourse based on facts. That's what we're here to do today. Specifically, we thank DCJS's Executive Deputy Commissioner and Deputy Commissioner of the Office of Justice Research, Joe Popkin and Lee Bates, and their teams for leading these research efforts. You will hear from them later today, along with Mike Rempel, the Director of John Jay's Data Collaborative for Justice, and Crystal Rodriguez, the Policy Director for the Data Collaborative for Justice. But now, I want to introduce somebody special who really makes this work her life's mission. I am proud to introduce Rosanna Rosado, who is leading the Division of Criminal Justice Services. Not only is Rosanna an accomplished public servant, having been our Secretary of State before this role, she has been a tireless worker to create more fair and equitable criminal legal system. And she is so committed to this work that while working full-time, she went back and got a master's degree in criminal justice from John Jay. So please welcome Rosanna.
Thank you, President Mason. It's wonderful to be with you and the John Jay College team, which I consider my family, for today's webinar. I've often said that John Jay College is like the United Nations for criminal justice issues. There are few places that can bring together such a diversity of perspectives. As a former student and lecturer, it was an incredible experience to share different insights to help build knowledge. Now, as a policymaker, it is invaluable to have spaces like these to convene and discuss the most pressing issues regarding safety and justice. So thank you for being our partner. At the Division of Criminal Justice Services, our goal is to keep New Yorkers safe and ensure a justice system that works for all. Our mission is to enhance public safety by providing resources and services that inform decision-making and improve the quality of the criminal justice system. This year is DCJS's 50th anniversary this fall. Through the years, we have continued to evolve with the justice system and gained invaluable experience working with all the stakeholders. We know where the system has been, we know where it is now in a moment of change, and we have the vision to seize this moment to help guide it forward. One of the most recent changes, and the topic of today's webinar, is bail reform. In January of 2020, just weeks before the COVID-19 pandemic hit New York, the new pretrial law took effect. It significantly changed pretrial and bail procedures that had been the same for nearly 50 years. These changes were driven by the need to make pretrial release decisions more equitable, reducing racial disparities. Remember that, reducing racial disparities and removing the perverse connection between financial means and freedom. This unnecessary detention was deeply harmful to individuals, families, and communities, particularly those of color and the poorest among us. Under the new law, DCJS and the Office of Court Administration collaborated to publish data on pretrial release. That data is available on our and the OCA website for anyone to review and analyze. It has been the primary source of information for the public and has been extensively discussed in the press and among policymakers. However, the data showed an incomplete picture. It had comprehensive data from 2020 and 2021, the first 2 years after the reform, but it did not have data from 2019, before the reform. So we are looking at apples and oranges when we tried to compare the pre and post reform systems at a time when the pandemic also fundamentally disrupted the justice system. Since earlier this year, some of the best and brightest minds at DCJS and OCA have been working to identify, compile, and analyze pre-reform information from 2019 to provide a baseline that can be used to show the impact of pretrial reform. Today, we present and provide that data. To me, this is a small yet critical step to shed light on the conversations that are happening at that intersection of justice and safety. At DCJS, we embrace data-driven and evidence-based strategies to tackle complex challenges. I want to thank Governor Kathy Hochul for her continued support of our agency and for securing dedicated pretrial services funding in this year's enacted budget. As you will see from the existing and new data, supporting services for those who are released under supervision or with conditions is critical to the success of these reforms. We will soon share more about the distribution of these resources, which will be used by local community-based providers and probation departments throughout the state. I also want to thank the entire DCJS team for their dedication and commitment to the agency and its mission. Specifically, I want to thank our Office of Justice Research and Performance, who have been instrumental in this effort. Our sincere hope is that this new information helps all of us move our justice system forward and ensure that it works fairly, equitably, and efficiently for all New Yorkers. With that, I will now turn the program over to Joseph Popkin, Executive Deputy Commissioner here at DCJS. Thank you.
Thank you very much, Commissioner. And good afternoon, everyone. I would like to just say thank you to President Mason and Commissioner Rosado for your leadership and service to improve New York's criminal justice system. As many of you know, the bail statute that we have today in New York is a culmination of years of debate and advocacy regarding pretrial procedures and detention, which had been largely unchanged since 1971 up until 2020. And as a result of the negotiations among lawmakers and criminal justice leaders, those new bail laws took effect in 2020. Soon after the law took effect, the pandemic caused far-reaching disruptions followed by 2 rounds of amendments to the statute. The convenings that President Mason mentioned held earlier this May at John Jay College included some of the legislators and practitioners who were involved in the bail laws development and implementation, and it provides an important backdrop and resource for our program today. With that, I'd like to share a few highlights of the conference.
At the bottom line, we all want the same thing, which is we want a system that is fair and equitable that keeps our communities safe. It's just in the middle that we struggle a little bit with figuring out what do the contours of that look like.
To watch the narrative depart from the factual basis that we all hope it would rest on has been a challenge professionally.
What is bail? By definition, bail discriminates against the poor. You're asking people to pay for their freedom. For every New York Post headline about someone who did something awful or is accused of doing something awful, there's dozens of more who have more stable lives because of what we've done, who are home with their families, who get to keep their jobs while they're going through the system. And that ultimately makes us all safer.
I think bail reform was a terrible mistake. And I think it was based on a bunch of false assumptions.
When this legislation was formed, they should have brought in right-minded law enforcement people to at least give an idea of what was necessary or the pieces that should have been mentioned or put in to fix things.
The goal of bail reform is now and always has been to reduce the number of people who are held pretrial in this state. By that standard, bail reform has worked and is working.
Every serious study has indicated that there's no connection between bail reform and the rising crime, because crime has been rising all across the country.
I think one thing that journalists need to do more is put into context the ways in which pretrial detention can drive crime up.
No evidence that bail reform is linked to increases in violent crimes. There has been an uptick. We should be taking that seriously instead of using bail reform as the reason for why this is happening.
When you get such transformational policy, well-intended as I'm sure they were, there are no directions that come with it. And in this instance, neither was there any funding.
First and foremost, we talk about data and numbers and the intent of the law, and behind every number is a person, with needs, with their own story, who's tied to community, with family.
So at a constitutional level, it means that we've sort of fundamentally violated their presumption of innocence, that arraignments last 30 seconds or a minute, there is no finding of guilt, and this person is then behind bars, either on bail they cannot afford, or in cases where they've been remanded.
One system, it's one bail law, and it's two realities. And so what the original bail reform was about was trying to create a more equitable system. A system where somebody isn't held in on bail because they can't make $500 bail.
When is the state entitled to deprive somebody of liberty? On what basis, and then in what conditions should they be held while they're awaiting trial? This is not a new question. Let's remember the Constitution. Let's remember the values implied in that Constitution. Let's remember due process. Let's remember the presumption of innocence. Let's remember the prohibition against, guess what, excessive bail. Let's remember the guarantee of a speedy trial. So the language that we can use that I think helps us find common ground with others is the language of defending our Constitution.
Thank you to the entire John Jay College team for that conference and continued convenings on priority justice issues, both within New York State and across the country. Now I would like to introduce Lee Bates, our Deputy Commissioner for Justice Research and Performance, to share the DCJS presentation. We will take questions later on using the Q&A function in the Zoom taskbar, so please send your questions and we will get to them as we can at the end. As Commissioner Rosado mentioned, today's presentation is a first look at new data and analysis, which includes pretrial release decisions for arraignments that occurred between January 1st, 2019 and December 31st, 2021, to inform the public about the impact and implementation of these reforms. This is the first time that we were presenting 2019 data to provide a baseline of the justice system before the reforms. Following the January 1st, 2020 effective date, there have been two series of amendments to the reforms which are included on this slide. The first in 2020 added new offenses, qualifying offenses in which bail could be set, and circumstances, and those took effect 6 months after the law first took effect from January to July. This year, additional changes were made to clarify and expand the factors that judges must consider when setting bail, expand arrest eligibility and bail eligibility for repeat offenses and hate crimes, and expanding bail eligibility for gun offenses. And so you can see some of those here. And with that, I'll turn it over to Lee to walk through more of the data. Thank you, Lee.
Thank you, Joe. I'm Lee Bates, Deputy Commissioner in the Office of Justice Research and Performance at DCJS. And today I will be sharing a little bit of information about our supplemental pretrial release data file. As you heard from Commissioner Rosado and from Joe, we have a data file that we've prepared, a comprehensive data file about pretrial release decisions compiled with the Office of Court Administration. This file is posted on both of our websites and includes pretty detailed information about arraignments in 2020 and 2021. We also coordinated with OCA to develop this supplemental file, which includes pretrial release outcomes from arraignments in 2019. A little bit of a description about this data file. We're using what DCJS calls our top charge file. So this is the top charge at arrest, arraignment, and disposition for adult criminal arrest cycles. It includes about 560,000 cycles beginning in January 1st, 2020 2019 through December 31st, 2021, including fingerprintable felonies and misdemeanors from New York City criminal courts and city and district courts outside New York City. It does also include some Superior Court activity as Superior Courts began reporting in 2021, but Superior Court information should not be considered complete at this time. Next, we'll look at trends in pretrial release. This starts here with a little bit of a look at our jail populations. We see jail populations, beginning September 2019, starting to come down at the end of 2019 in anticipation of bail reform. We see those populations decline in 2020 in January when the bail reform takes effect, and then really bottoms out sort of with the pandemic, the height of the pandemic in mid-2020, early in mid-2020. Those populations started to increase again towards the end of 2020, and now by December of 2021 are near pre-pandemic levels. We see also here our arraignment volume, and this is a similar trend showing declines in arraignments towards the end of 2019. When COVID hits and we see the height of the pandemic, the arraignment volume is at its lowest and then starts to pick back up again in late 2020 and early 2021. Now at the end of 2021, we're near where we were with the pre-pandemic and pre-reform levels. What we do see, though, is that the mix of cases being arraigned has changed over time. Early in 2019, looking here at this chart on the left, we see the black line showing the arraignment volume, which is the same as it was on the last slide. And then the bars show the mix of the charge severity. So early on in 2019, misdemeanors were 77% of arraignments in New York City. Nonviolent felonies, this orange part, are about 14%, and violent felonies were 8%. We see during the pandemic, when volume really was lowest, that mix changed pretty dramatically, with misdemeanors dropping to about 63% of cases, nonviolent felonies 17%, and violent felonies were up to 20% of arraignments moving through the courts in 2020. Now, back at the end of 2021, we're back to those pre-reform, pre-pandemic levels. About 75% of cases being arraigned are misdemeanors in New York City. We're back to 11-12% being nonviolent felonies and 13-14% being violent felonies. So still a little bit higher than it was in 2019. In non-New York City and district courts, we see a similar trend, although the volume is lower outside New York City. That mix of misdemeanor cases still declined drastically in 2020, and now in 2021 is back to where it was early in 2019. We see nonviolent felonies as well, 24% early on, increasing to 30% and back to 24%. And then these violent felonies, 7%, 19% in 2020 at the height of the pandemic, and back to 10%. Next, we're going to take a little bit of a look at the release decisions. This is a little bit of a dense chart, so I'm going to spend just a minute explaining what it is we're looking at. This shows overall and by charge severity the total arraignments that were moved through the courts in 2019 is the top bar, 2020 and 2021. When we look at this dark blue portion of the bar, we see the proportion of cases that were released on recognizance or ROR. We see in New York City in 2019, 75% of those arraignments were released on recognizance. 5% were released under supervision or non-monetary release conditions. That's this bright blue portion of the bar. And then 20% had bail set. That's the gold portion. 1% in this dark red were ordered remand. I'm going to focus in here on the total arraignments. Looking overall, we see that the use of ROR, or release on recognizance, has actually decreased over time from 75% of all arraignments in 2019 to 67% in 2021. We see this proportion that were released under supervision or non-monetary conditions tripling in proportion, 5% up to 16%, and then the proportion that were ordered bail decreased from 20 to 16%. Overall, we see that remand was very stable and low at 1% of all cases. We know that, though, that release decisions can depend heavily on the severity of the offense. So we look here at violent felonies, and we're seeing the same trends where ROR, even among violent felonies, decreased over time, moving from 37% in 2019 to 24% in 2021. We see this big increase in the proportion of cases released under supervision or non-monetary release conditions, increasing from 3% in 2019 to 23% in 2021. Meanwhile, bail set decreased slightly from 57 to 49%, and we see that remand is still fairly stable at 3 or 4% of cases. Outside of New York City, we see a little bit of a different trend where ROR is more often used post-reform, and that's even with the BFOs. When we look at overall cases, we see ROR, release on recognizance, increasing from 52 to 61%, and release under supervision or non-monetary release conditions increasing from 7 to 14%, and we see this big reduction in bail set upstate, decreasing from 35% of overall cases arraignments in 2019 to 19%. Upstate, we do see that the use of remand is higher than it was in New York City, but still pretty stable at 6% sort of across the board. Looking at violent felonies, we see similar trends, slight increases in ROR, 10 to 13%, much bigger increases in RUS from 6 to 15%, and then decreases in bail set, 66 to 52%. Overall, we see that remand is highest among VFOs upstate, but still stable around 18% of arraignments. Perhaps the biggest change was for nonviolent felonies upstate, where ROR increased from 29 to 48% of arraignments over the 3-year period. This use of release under supervision or non-monetary release conditions increased from 8% in 2019 to 20% in 2021. And then bail set really was decreased dramatically from 48% of cases in 2019 to 19% in 2021. We also see here that remand decreases slightly from 16 to 13%. So overall, we're seeing some slightly different trends between New York City and upstate. We see that release on recognizance decreased in New York City and increased upstate. We see that non-monetary release conditions increased in both regions and that bail set decreased, especially in non-New York City. With the bail set decreasing, we look here at the amount of bail that was ordered. As fewer cases are ordered bail, only the more serious cases have bail ordered. Those amounts being ordered are higher. When we look here at the dark red portion of the bar, which is showing the percentage of cases where bail is set at $10,001 or more, we see that use of high bail increases from 16-17% early on in 2019 in New York City to 32% by the end of 2021. We see similar trends upstate, although bail set is lower. Overall, we see that high bail set at 15% early in 2019, and that goes up to 21% at the end of 21. Although it's not shown on these charts, we do know that median bail also increased. I got to find that in my notes though. We know that median bail increased from $3,500 early in 2019 up to $10,000 in 2021 in New York City. And we know that median bail increased from $2,500 upstate in 2019 to $5,000 in 2021. What's also notable on these charts is this gold bar, which shows a dollar bail. Dollar bail being set generally indicates that a case is being held on a different matter. And we see the use of dollar bail, that nominal bail, increasing both in New York City, where it goes from 12% to 28%, and then especially upstate, where it goes from less than 1% in 2019 to 22% in 2021. As we see the amount of bail set increasing in New York City and upstate, we also see that the percent of cases able to pay bail has decreased over time. If we're looking at this orange bar, the orange bar shows the percentage of cases where bail was not paid. We use 5 days as our cutoff here because our analyses have shown in the past that generally speaking, most cases that do pay bail have paid bail within 5 days. So using our 5-day cutoff, the percentage of cases not able to pay bail increased from 69% in 2019 to 79% in 2021. We see similar increases upstate as well, where the percent of cases not able to pay bail increased from 63 to 81%. So at the end of the day, the question is what happens with pretrial release outcomes? We see release conditions changing, the type of release ordered has changed. We see that ROR comes down in New York City, goes up in upstate. We see that bail is ordered less frequently, but when it's ordered, it's at high amounts and people are less likely to pay. This set of bars shows us what those release outcomes are after taking all of that into consideration. Overall, in New York City, we see very little change in the percentage of cases that are actually released, going from 86% in 2019 to 87% in 2020 and 2021. We know, however, that 75% of those cases in 2019 and 21 were misdemeanor offenses, which are largely released before and after bail reform. When we look at these by charge severity, we do see a little bit of a difference with a slight increase among violent felony arraignments in the percentage of cases being released from 58% to 62% in New York City. And among nonviolent felony cases, we see that percent released increasing from 74 to 80%. Again, these bigger changes are occurring in the type of release with less ROR and more RUS or release under supervision or non-monetary conditions. Upstate, we do see these increases in percent of cases released. Overall, 72% of all arraignments in 2019 were released, compared to 79% in 2021. We see that increase in violent felonies, again, where ROR is used slightly more often and the RUS, or release under conditions, is used much more often, increasing from 37 to 43% for violent felonies. And then we do see a big increase among nonviolent felonies in the percent of cases that are released, from 54% in 2019 up to 21% in 2021. Looking quickly here at time to disposition, this chart shows us on the line the median time to disposition for all arraignments in New York City, and then by charge severity. We see in 2020 that the median time to disposition, so the day from arraignment to final case disposition, increased pretty markedly as much of life in 2020 slowed down due to the pandemic. And then those times to disposition came back down in 2021. Here, we're just looking at the first 9 months of 2021, allowing at least 6 months of time to observe final case disposition, as we'll see later, 6 months to observe failures to appear and rearrest as well. So here we're just including January through September of 2021. We see also big increases in median time to disposition among violent felonies, and then among nonviolent felonies and misdemeanors as well. The bars are showing us the percentage of cases that, as of May 2022, still had not yet been disposed. So among these violent felonies, there's still 37% of cases that haven't been disposed. So this median time to disposition, we would expect to see some increases in that by the time the cases get disposed. Outside, we see similar trends where there was an increase in time to disposition in 2020, and then it starts to come back down in 2021. Upstate, it doesn't come down quite as far as it did in New York City, and we also see that there are bigger percentages of cases that are still undisposed. 42% of violent felonies arraigned between January and September of 2021 had not yet been disposed as of May 2022. And this will matter only in terms of looking at success in pretrial supervision or success in pretrial looking at failure to appear and rearrest rates. So looking at failure to appear, we're showing here the failure to appear, the FTA rates in New York City criminal courts and non-New York City and district courts, showing here by year and then also by release category. Among all releases, we see that in New York City, this FTA rate declined over time from 15% of all releases in 2019 to 8 and 9% in 2020 and the first 9 months of 2021. Upstate, we don't see those declines. We see this FTA being stable upstate at 17, 19, 18%. We also see that the FTA rate is highest among those cases released under supervision or non-monetary release conditions. It does come down in New York City from 34% FTA rate in 2019 to 19 and 20% in 2020 and 2021, but it's still much higher than the other release categories. Upstate, we see that it's also higher and stable over time at 24% FTA. When we look at rearrests here, again, we're looking just at the first 9 months of 2021, and here we're censoring on 180 days. This is in part to account for the fact that arraignments in 2020 took longer to dispose. So in order to improve the comparability over time, everybody in every year is followed for 180 days, and then we kind of stop the clock and stop looking for rearrests. When we look at rearrests at 180 days in New York City, we see that rearrests decrease marginally for ROR and also for bail paid, going from 18, 19% down to 16%, and then 24% down to 21 and 19. We also see in New York City that the rearrest rates were highest and were stable for release under supervision or non-monetary release conditions at 39 and 40%. Upstate, we see that rearrests were highest for release under supervision or non-monetary release conditions at 22, 32, and 30%. We see they're also high for bail paid. Upstate, we don't see them come down even marginally. They're a little higher upstate than they were in New York City, not coming down quite as far. Next, we look at firearm arraignments. And let me click here. The firearm arraignments are those cases where the top charge at arraignment included the use, display, possession of a firearm, or what appeared to be a firearm. And I think we have the definition here on our charts. Most arraignments for firearm offenses are violent felony offenses. So this is showing pretrial release outcomes where there is an increase in the percentage of cases that are released, a marginal increase from 58% in 2019 up to 60, 63% in 2021. Again, the bigger changes occur with the type of release where it's less release on recognizance and more release under supervision. We see that release increase also upstate, where the percentage of cases released goes from 31, 39, 33% up to about 40% in 2021. When we look at rearrests, we see that the rearrests are lower in general for the firearm arraignments, at 15, 16, 14%. There's not a lot of change over time. And we see that they're marginally more likely to be rearrested for a firearm offense. So where somebody is arrested and arraigned on a firearm charge, they are slightly more likely to be rearrested for a firearm. That's still a pretty rare event at 2 or 3% of cases. Finally, I will show here where the data are available. I believe they are posted to the data set or will be later this afternoon on DCJS's statistics page. We have the data file that's posted, as well as our source notes, our data dictionary, and the summary tables. And I believe I'm handing over to Crystal.
All right, Crystal, I think you might be on mute.
Great, thank you, Joe. Thank you, Lee, for that comprehensive presentation. I'm Crystal Rodriguez, the Policy Director of the Data Collaborative for Justice at John Jay College. I wanted to start by, we're offering a primer on what is contained in the bail reform statute, and this will be a brief overview. Starting with historical context. Sorry, one moment. I apologize. I'm unable to change my screen. One moment. I'm going to stop this share. What I'm going to do is switch to the, here we go. So I'm going to leave it in this format for now, just to make sure that I'm able to switch the screen. So moving on to the next slide. Here we go. I wanted to offer some historical context. As we all are familiar with, the rationale, the goal behind the use of bail is to ensure an individual's reappearance in court after they've been arraigned during the pretrial period. The other thing I would like to note is that this has always been the purpose of our bail statute in New York State, to provide a monetary incentive for folks to return, but to provide an avenue for release when bail is set at an affordable rate. Now, the options that existed prior to any changes to the bail law included release on an individual's own recognizance with no pretrial conditions, or money bail. Those were the two that were most often used. Remand, as was cited in Lee's presentation, was also an option, but was not used nearly as much as these other two considerations. I'd like to move on to what occurred in 2019 or 2020 when the statute went into effect. What the bail law sought to do is consider ways to limit the use of bail. And given the use of bail, I wanted another note to consider is that one of the original purposes of bail in ensuring return to court did not include an evaluation or consideration of public safety risks. That is not a consequence of the changes to the bail law. Rather, that is a continuance of the status quo for New York State. That has never been a consideration. Looking at the ways in which our current statute seeks to limit the use of money bail, it does so in 4 key ways. First, by charge, by factual circumstances, and by considering finances, also by prioritizing release. And I'd like to cover that a little more closely. The statute does include a comprehensive and detailed list of qualifying offenses. What I'd like to highlight quickly here is the violent felony offenses is specifically those that are included in the penal law and categorized as such in penal law section 70.02. There are few carve-out exceptions to that provision, but I wanted to know, as we mentioned, that the firearm charges most commonly seen in courts, criminal possession of a weapon in the 2nd degree, is included on the list of violent felony offenses. So that means that happens to be a charge that can be eligible for bail, and that has not changed before 2020 and post 2020. Moving along, as was noted, there have been amendments to the statute. As those amendments have come into effect, more offenses have now become eligible for bail. And zeroing in again on gun offenses, those were specifically added to the statute, which include some examples are criminal possession of a gun on school grounds, criminal sale of a firearm to a minor are among those charges that were added. Now, thinking about the factual circumstances, there are certain set of facts independent of the charge that could make an individual eligible for bail. So any felony charge where someone is on community supervision can make that individual bail eligible on the felony for which they appear in front of the court. If they can potentially be sentenced as a persistent felony offender and are before the court with a new felony, that's also a scenario where someone can be bail eligible. I want to talk about the harm to harm provision because I think, or what people refer to as the harm to harm provision, I think this creates some further opportunities or scenarios where a court can set bail. And this is a scenario where an individual is before the court on a second arrest while having a previous arrest that is still pending in court. And both charges, the one before the court and the one that predates it, involve this harm to an identifiable person or property, or the criminal possession of firearm charge. The consideration of finances also seeks to limit bail in the scenarios where bail is even on the table. So assuming that one or two of the categories we just went over are met, and the judge is considering bail, the statute guides judges to consider an individual's financial circumstances and an ability to actually pay the amount that is set by the judge without undue hardship. The second requirement that must be met is that courts issue bail with a third form of payment that is more accessible for the individuals going through the criminal justice system during their pretrial period, and that is to set bail in form of an unsecured or partially secured surety bond. And what I want to say about this is that these alternative forms of bail have been on the statute for 50 years. The distinction here, or what bail reform changed, was that it is now required that the court set bail in one of these forms. Now, another thing the statute does is create a framework that creates more avenues toward release. So there's a built-in presumption that individuals will be released unless they present or pose a risk of flight to flee prosecution, meaning that they will not return to court. If that risk of flight is found, even then, if that court makes the individualized determination that there is a risk of flight, the court is still directed to consider what may be the least restrictive condition possible to ensure that person's return to court and their compliance with the court requirements. Now, this is where the statute fills in a gap that previously existed between releasing an individual with absolutely no conditions or using money bail and requiring that that person be detained unless they can afford that bail. In that space, the statute fills a variety of non-monetary conditions. This is not by any means an extensive list, nor is the list that's included in the statute exhaustive. The court can use other conditions that they deem appropriate, but I did want to call attention to a few of them. One of them being contact with or supervision by the pretrial service agencies is an option that now is legally required to be available to the court and individuals going through the criminal justice system. A few notes on this: it's now required that counties across the state provide this service, which is important that support has been provided for the service to be built out throughout the state. Other interesting, I think, non-monetary conditions include mental health assessments that we can talk a lot about the requirements that go with that. There's also mandatory programming that enables the court to respond to individuals' needs at that point as they appear before the court. We are there's other, as I mentioned, there are other non-monetary conditions included that are important, and we see that there are findings that the courts, at least up to now, seem to be looking to use much more of these non-monetary restrictions to ensure that people return to court in light of the changes to the bail statute. We will be available to continue answering questions at the end of the program, and our slides we put up after this program. I'd like to, at this point, turn it over to Michael Rumpel to share some of the evidence about bail reform across the state. Thank you.
Okay, and Crystal, when you go ahead to the next slide, my name is Mike Rumpel. I am the director of the Data Collaborative for Justice at John Jay College. My role today is really to synthesize and try to do it so that we can get to Q&A by about 1:30. So looking both at Lee's presentation and also integrating what we know from other completed research on New York's bail reform, what have we learned? Well, we've learned it's complicated. We've learned bail reform is a work in progress. We've certainly learned, and I'll get to this momentarily, that implementation has not been perfect. We've also learned that it is clear bail reform is achieving some of its original goals. I'm going to get to that right from the outset and focusing on the effective bail reform on pretrial decision-making. I think we know at least 5 things. And first and foremost, we know that bail reform, as expected and intended, has had some effect in reducing the prevalence of bail and the prevalence of pretrial detention. And as Carol Mason noted in her opening comments, at the Data Collaborative, we estimated that right about 19,000 fewer cases were detained in 2020 as a result of changes in pretrial decision-making corresponding to the new bail law. But second, as Lee's presentation, I think, made clear, we also know that there's a lot of variability between regions, and as other research has indicated, between counties, and that variability is in the prevalence of different pretrial conditions before bail reform was implemented, after it was implemented, and variability in the change from the pre-period to the post-period. I'm just going to underscore one point that I think we already made in her earlier presentation related to ROR rates. We expect that ROR rates would increase under bail reform, and that relates to the presumption of release to which Crystal alluded in her presentation about the law. And that is exactly what we've seen outside New York City. But in New York City, we've actually seen a decline in ROR rates from 2019 and then looking over to 2021. Third, staying with the theme of ROR, but turning now to an area where I think there is not as much variability and a sort of a constant theme throughout the state. We know that both before and after the reforms, courts appear reticent to use ROR in violent felony cases specifically, and you can see the statistics. The statistics in red are for 2021. In 2021, the ROR rate was 24% in these serious cases in the city. And although outside of the city, it increased, looking back to 2019 when it was 10%, we're still only at 13 percentage points. I think we can all understand why judges are reticent to set ROR in violent felony cases. Yet, it is worth noting that research that we showed and that others have conducted indicate that people of all charges, by and large, do attend all of their court dates. FTA rates tend to be around 15 or 16% overall. And we also know from research by CJA and others that the severity of the charge, or for that matter, anything about the current charge, tends, perhaps counterintuitively, to be a poor predictor of someone's likelihood of returning to court. Go ahead to the next slide. The fourth thing we know, I think we know that the implementation of bail reform has not been uniform. In fact, after an initial sharp drop in bail setting, what we saw was beginning around the spring of 2020, there was in all parts of the state a re-uptick in bail setting. And in part, this explains a very early slide in Lee's presentation when she pointed to changes in pretrial jail populations throughout the bail reform era. And you could see that it dropped by a great amount and then has been gradually rising since around the middle of 2020 on to the present. So we know that implementation has not been constant throughout the reform period. Finally, and here I do want to underscore what I think can only be interpreted as an implementation deficit. We know from Lee's presentation and other research that bail payment rates have declined since bail reform was implemented, despite the provisions to which Crystal alluded regarding affordability. And I'm just going to underscore the statistics at the bottom of this slide, drawn from Lee's presentation, that in 2021, around 10%, or actually exactly 10% of people who had to pay bail still in New York City could do so in 2020. It was around 11% outside of the city. And then even within 5 days, we're at just over 20% across the state of people who could afford bail. Okay, let's go on to the next slide. Well, okay, what about the relationship between bail reform and crime? Well, I'm going to disappoint everyone viewing this webinar. There is no big reveal today indicating definitively whether bail reform reduces or increases crime or recidivism. That will have to await further research involving matched samples and common tracking periods. But does that really mean we know nothing? It doesn't. There's been prior research actually in prior years before bail reform was passed in New York City, as well as a number of other cities. You can see them on the slide: Houston, Miami, Pittsburgh, Philadelphia, Kentucky, the state of Kentucky. And it all really points to two common findings. Step one, when people face bail, which often leads them to be detained because they cannot pay, pretrial recidivism rates decline. That's what the research shows, but in a sense, that's by definition. If you detain people during the pretrial period, they've been incapacitated and are unavailable to engage in any type of further criminal behavior. This prior research in these cities on the slide also indicate that once people are ultimately released, those who have been detained pretrial tend to have higher recidivism rates than those who have been released. And so in the end of the studies shown on this slide, there is actually not a single study that supports the recidivism reducing benefits of detaining people. It's more the opposite. Pretrial detention tends to modestly increase rearrest rates. We also have had research testing bail reform in other jurisdictions: Cook County, Illinois, Harris County, Texas, New Jersey, across the state, and Philadelphia. And none of these 4 studies have indicated a link between bail reform and crime or recidivism. And in fact, the evaluation of New Jersey's bail reform found a significant reduction in misdemeanor crime timed to the period right after bail reform was put into effect. All right, let's go to the next slide. We also have learned a few new things from Lee's presentation about rearrest rates. And here I want to just focus on the high level and sort of extract us away from the details. What Lee has shown us is about what, generally speaking, pretrial arrest looks like. And sort of averaging the statistics across her rearrest slides by year and by region, it appears plus or minus a few percentage points that pretrial rearrest rates are at about 20%. Violent felony rearrest rates are at or below 5%. Firearm rearrest rates, depending on which year we're talking about or which region we're talking about, would be 0% or 1%. So this establishes an expectation on what rearrest rates look like and on the relatively low prevalence of violent felony and firearms rearrest. Okay, go to the next slide. Okay, so what do we have to do from here? Well, what we have to do for New York is to see if what has been found in other jurisdictions is true, or if the findings related to New York's bail reform in fact are different. And that requires a true apples to apples comparison where we're not only comparing 2019 people who faced bail to 2020 people who were released, but we're actually ensuring that we're matching them so that we're comparing apples to apples on charges and criminal histories, and we're looking at equal tracking periods. We also have to look at rearrest rates during both the pretrial and the post-disposition periods, and that relates to prior research, which shows that what we see when we only focus on pretrial rearrest rates is a little different from what we see when we include a post-disposition time frame, where we tend to see that people who have been detained tend to have elevated rearrest rates after their release due to the harms they experience while in jail. So that is something we would want to test in New York and see if prior research has been replicated or not. And finally, to do any of this, we need data transparency. And so now I'm just wrapping up with a note of thanks to DCJS and OCA for their data transparency, but let's go to the next slide. That transparency extends not only to today's release, but in fact, DCJS and OCA also share data with researchers all the time. And having done national research, I can share with those viewing this webinar that there is not a state in which I've done research where the quality of data matches New York. Truly, and you can see some of the agencies on the side that have already completed studies of bail reform. And I just want to conclude with, I guess, a note of advertisement. We are going to, at John Jay, maintain a bail reform research resources page. It can be found off of our website from the May 2022 bail convening. We're going to continue to update it as more research comes out so that people can see the results of this transparency. So again, with that, thank you so much to DCJS for this latest release and for the past years of transparency. And also thank you so much to our wonderful colleagues at the Office of Court Administration's Division of Technology for their work sharing data. And with that, Joe, I think I'm going to turn it back to you.
Thank you so much, Mike and Crystal, for your presentation and for your transparency, and that's what we're trying to do today. So with that, I think we'll take some more questions. We've been answering them kind of as the webinar's been going, but I'd like to rely on some of the experts here. So the first question I'll actually pitch to Lee, which is, despite the same set of state laws, New York City and the rest of the state seem to function differently, both before and after the bail reforms took effect. And that was in your presentation as well as Mike's. Is that a surprising finding? And has anyone kind of examined those regional differences?
Thanks, Joe. I think the finding is probably not all that surprising. If people are doing research in New York, I think on criminal justice in particular, it's very common that there are differences, regional differences between New York City and upstate. And much of the reporting that we at DCJS do on our statistics page and with other reports separates out New York City and upstate because there are so many differences, and much of this is very, very local. So I expect that even if we were to break rest of state into some of those regions, we may see some of those differences as well.
Thank you, Lee. And on that point about local, I think we had a question in the chat about data from town and village courts. Can you talk a little bit about that?
This data set does not include town and village courts, and so that's an excellent point to keep in mind. We know that the town and village courts arraignment volume is about half of upstate's arraignment volume, with the city and district courts being the other half. So as the town and village courts are rolled into the pretrial release data, I think it'll be interesting to see what's happening and see if there are changes. I'm not sure the exact date of that. I think it's in the works. And so stay tuned for folks who are interested in the town and village.
Thank you, Lee. Next question to Mike. Based on this information and the earlier data collected, you talked a little bit about some of the other jurisdictions, but how has New York's bail reform, implementation and impact been similar or different in your mind from, like, let's say, New Jersey?
Oh, great. I really love that question. There have been a number of bail reform schemes tried in different places, and New Jersey is next door. Their scheme's been in place for a while. I'm going to give the high level. Based on what we know, it is a very different scheme than New York's, yet it looks like some of the results ultimately are quite similar. So a few differences between these two schemes. New Jersey's virtually eliminates bail, not entirely, but it virtually eliminates bail. It's essentially a bail elimination scheme. New York's is not, as Crystal indicated, and as the data shows, bail is still an option in a great many cases. Secondly, as Crystal also indicated, really for over 5 decades, pretrial decision-making in New York has been based on likelihood of court attendance, and now even a more stringent standard of risk of flight before one can set pretrial conditions. In New Jersey, public safety considerations are admissible, and in fact, the scheme depends upon a formal risk assessment to direct judges towards whether they should detain people or whether they should release them, or even what types of supervision levels they should use. That's different. New Jersey's law has more process. There's a formal hearing that must take place whenever preventive detention is an option. Okay, so those are a few differences, but with all of that said, New Jersey's reforms have been evaluated, and we've had some studies in New York. Both laws appear to be achieving reductions in pretrial detention, as both were intended to do. Both laws have reduced pretrial detention for all racial and ethnic groups, as they were intended to do. However, both laws have not reduced relative racial disparities, perhaps contrary to what we had desired to have happen. And by that, I simply mean that of the smaller denominator of people who continue to be detained, the proportions from different racial and ethnic groups have remained such that the jail populations have remained predominantly Black and brown. And then finally, what we don't know definitively in New York is its effects on crime and recidivism, although as I mentioned, New Jersey's law has been in place for longer. And we do know that there has been no overall effect on recidivism and a modest effect in reducing misdemeanor crime.
Thank you very much. To that point, I just want to ask Crystal a little bit about, since there are so many different schemes and the bail reforms have changed several times, what is the thing that you think is the greatest misunderstanding here in New York about the bail reform law itself?
Sure. I highlighted some of them, but I think it bears repeating. There's been a lot of conversation regarding bail reform and its limitation on judges and considering risk to public safety, dangerousness. Now, this is something that is present in other jurisdictions as a factor that courts can consider. However, New York state law has never included that particular factor. So it is not a consequence of the bail reform statute that is not in the law. There's also a lot of conversation around what particular charges are actually eligible for bail, when can judges use them, and this has come up a lot in the context of shootings and gun possession, because we have seen a spike beginning in the mid 2020 in those particular offenses. Those offenses are commonly charged as criminal possession of a weapon in the second degree, and where there's actually been an actual shooting or assault of a person using a gun, that's charged as an assault in the second degree, both of which are included as violent felony offenses. So it doesn't mean that judges have to use bail for those cases, but I think it's worth clarifying that it does remain an option for courts in those particular instances.
Thank you, Crystal. I appreciate that. Lee, to go back to you for a second, there was a question about desk appearance tickets that was in the chat. It says, does the bail paid within, sorry, wrong one. Does the release data include the issuance of appearance tickets by arresting officers, or does it reflect release decisions at first appearance?
The data reflects the release decision at first appearance. Our data starts with a statutorily required data, which is posted on OCA's data set beginning at arraignment. So if there's a desk appearance ticket and the person hasn't yet been arraigned, that case doesn't come into our data set. So it's first arraignment decisions.
Thank you. To go to Mike a little bit, I think you talked about this in your presentation, but it seems like on the one hand, bail reform seems to have its intended effects, right? Reducing pretrial detention, particularly outside of New York City, and reducing failures to appear, particularly in New York City. But on the other hand, I think we've seen from the DCJS data that releases under supervision or with non-monetary conditions have increased, and they're also the kind of greatest rates of failure to return to court and are facing rearrest at greater rates. You know, what would, in your ideal world, what would the next research kind of cohort look like, or what is the research enterprise that you know, ought to be undertaken to better understand those dynamics?
Right, that's another great question. I really urge caution in looking at some of those marginal differences between different pretrial conditions, because, for example, people who face ROR on average tend to be a little bit lower risk by definition than people who face supervised release or perhaps face bail. So therefore, much like testing the overall effects of bail reform, in testing the effects of release under different conditions, compared to themselves and compared to ROR, what we really need is some research that would sort of tease out these potential differences in people's baseline risk who end up in these different groups, in order to see if what looks like elevated rearrest rates of those in pretrial supervision is sort of a real negative effect of supervised release, or if it's an artifact of the inherent characteristics of people in supervised release. I also think, although this whole webinar has really emphasized quantitative data, that it would bear some process analysis to understand how supervised release is being implemented around the state. How intensive is it? What are the setups? What are the supervision levels that different jurisdictions are using? Are jurisdictions making use of something to which Crystal alluded in her presentation, mandatory programming, which is an option in the statute when a court is faced with perhaps a case where they want to set supervised release instead of bail, but where a more intensive form of supervision is required, and they're making any use of mandatory programming in order to adjust people's underlying needs. So those would be a few answers of what I'd like to see methodologically and what I'd like to see in examining the nature of the pretrial supervision that's delivered.
Thank you very much. Lee, just to jump back to you for a second, there's a question in the chat about when we talk about the severity of rearrest rates, are we considering any rearrest or just the first rearrest?
So the tables that we have posted online are showing the most serious rearrest within 180 days. What we have also in the data file are indicators. So if a person was rearrested at all for a violent felony offense, both within 180 days or during the entire pendency of the case, if it's more than 180 days, we'll have indicators for that. There are also indicators for whether or not a person was rearrested for a nonviolent felony and whether or not they were rearrested for a misdemeanor. We do include as well whether or not a person was rearrested for a firearm offense. Again, all of those are within 180 days, so it's very easy to take a comparable amount of time and follow-up period across all years of data, and then also during the entire pendency of the case were they rearrested for any of those.
Thank you, Lee. I think we'll do a few more questions. So you touched upon this, Mike, but this is really for anyone. The racial disparities, angle of the intended effects of the reforms. And so I know that's a variable, Lee, that is in the OCA data set, that's in our new DCJS data set, but are there kind of promising research that's either existing or forthcoming on the impact of bail reform on racial disparities?
Lee, do you want to take it first? Do you want me to go?
Sure. I can speak to what it is in the data file. We haven't done that deep dive yet. It is next on our list of things to dive into, and I agree with Mike, is just a really important consideration and an important research question to dig into.
Well, I'll go. So far, I'm not aware of research that's isolated racial disparities effects outside of New York City, but I was involved in a study with a former colleague of mine, Joanna Weil, and we did find, and I mentioned this earlier in looking at something that's also been found in New Jersey, that again, while bail setting declined for all racial and ethnic groups, there did not appear to be a reduction in the relative disparity. And actually, in the latter part of 2020, 2020, we found with violent felony cases in particular, there appeared to be a widening in relative racial disparities. So I think this is something we really want to look at. It was a goal of reform to reduce racial disparities. And so what is happening upstate and going into 2021, are we continuing to see some of the patterns that were not quite what we might have hoped for in New York City?
Thank you very much. I think we're about to conclude, but before that, I would just want to thank all of you, but also, is there anything that you want to highlight, or particularly, we can go around quickly and just say, what was a key takeaway from today and from the research from the past few months since the May convening? So I'll go to Lee first, and then Mike, and then Crystal.
I think one of the important key takeaways, which I'm going to steal from Mike here, is the transparency of the data. I imagine what the impact of bail reform is on all of these outcomes, we did not even really begin to look at today. Today was really very descriptive, sort of what's happening with case processing pre and post bail reform. The question of impact, though, I think is really important. And hopefully a lot of people can jump into this. A lot of people will have access to the data and can analyze it. And with all of us, spending a lot of time looking can help to form some conclusions, help to draw some conclusions about that.
I think I think a key takeaway is that we already know a lot. It sometimes doesn't seem that we know a lot because we have researchers waiting for a long enough tracking period to elapse before we can answer this question about bail reform's impact on recidivism. Although we do have research previously in other jurisdictions to help inform expectations. But we really do know a lot about pretrial decision-making, and Lee's presentation indicated that with all of the different analyses of effects on ROR, supervised release, and bail, and for different types of charges, other researchers dived into it. So I think for me, that's my takeaway. As far as pretrial decision-making, bail setting, people's ability to pay bail, we really do know quite a bit, both about what's working and about implementation deficits, even if we do want to, hopefully in the near future, answer more definitively than we have this question about recidivism effects.
Thank you, Mike. And Crystal?
Thinking about the bail reform convening that we held at John Jay back in May, one of the prevailing themes, consistent themes, was this question about data and the ability to have baseline data in order to do so much of the comparisons and respond to the questions that have been predominating the bail reform discussion. So I think that the fact that we're even able to engage in this conversation and that this data has been released is of great value. I think it allows us to continue to think about policy in an informed way with further analysis that's going to be happening, I'm sure, with the information that DCJS has provided that goes above and beyond the call of what the statute initially even required or anticipated.
Thank you, Crystal. And with that, I want to thank you all for your questions and participation in today's webinar. As we close this program, we'll refer you to the links that are in the chat. Just to let you know, the data has been posted onto the DCJS website. I think it was posted around 1:05 during the presentation. And we will make sure that a copy of the presentations are available on both the DCJS and the John Jay websites. Please pay attention for the John Jay Bail Conference webpage for more information on today's presentation, the PowerPoint slides, as well as future analysis and news on programming related to the new bail laws. Thank you all for joining us, and have a great day.